That's a good segue into the topic I'm going to discuss today, which is concurrent causation, or just in simple terms, just the policyholder's duty to segregate covered damages from non-covered damages, because on that house there was a lot of pre-existing damage that we had to account for. So I remember that claim pretty vividly, and I was absolutely shocked when I saw the bid for that fountain. It was almost as much as the roof. But before I jump into it, I wanted to give a round of applause to Sean Hodge and Cal and Melanie Spoon for putting this event on, getting everybody together, because I know it's a lot of work to do one of these events, so I really appreciate their work and inviting me up here to speak. Okay. So before we really jump into the details of concurrent causation, I mean, there are just a few just kind of general principles about insurance policies that we have to address. I mean, obviously, as we all know, under a property insurance policies, it typically only sudden and accidental direct physical loss to the premises or contents is covered. And typically, most of the policies that we all work with are what are called named peril policies. So it's got to be a named peril, fire, lightning, wind, hail, water damage, those are some of the, obviously the named perils we all deal with for the most part. Then you've got all risk policies, and I don't see a lot of those. I mean, I think Chubb, AIG, Private Client, they write them. Their all risk policies are really expensive, so we don't see them very often. But all risk covers all risks unless it's specifically excluded. And the typical exclusions that we all see are obviously flooding, mold, wear and tear, deterioration, pre-existing damage, cosmetic damage. That's the new thing they're all pulling. Everything's cosmetic, or lack of maintenance. Can anybody think of an exclusion that I forgot to put up there? Anything? Sometimes, settlement crack or earth movement. That's often thrown out there. Yeah, good one. Yeah, wind-driven rain. Love that one. You got to have a storm-created opening before it's covered. All right. So typically, I mean, if the policyholder files a claim and the insurance company accepts coverage, pays the claim, it's rare that any of somebody hires any of the folks in this room. But where you have coverage disputes, where the insurance company is denying coverage or underpaying the claim in Texas, and I primarily practice in Texas, the way it works is that the policyholder bears the burden to prove that it's a covered loss, one of the named perils that I showed you on the prior slide, wind, hail, tornado. Then the burden then shifts to the insurance company to prove that although it's covered, we agree there's a hailstorm, we found an exclusion. We think, this is all wear and tear, or it's blistering, or, all the damage is cosmetic, so we don't have to pay you anything. At that point, the burden then shifts back to the policyholder to prove an exception to the exclusion. It's not cosmetic, it's functional, There is a storm-created opening, it's not wind-driven rain. So where does concurrent causation, play its role in that analysis? Well, in Texas, the concurrent causation doctrine basically says that where you have a covered, hail damage and excluded peril that combine to cause a loss, the insured must present some evidence affording a jury a reasonable basis to allocate damage. And that's from this Lyons case that was a Texas Supreme Court case back in 1993. And then there's been a bunch of cases since then applying this doctrine and taking away coverage that would otherwise be there. Now, in that same case, the court also said that expert allocation of damages isn't necessary. So we'll go over some examples where it was simply just testimony from a neighbor or testimony from the PA that worked the file, saying, hey, 100% of this damage was from the hurricane. But a pro tip, I would say don't rely on just, testimony from a neighbor or somebody like that. I mean, hire experts. I mean, that is one thing I want to drive home with my discussion today is hire proper experts to document your damage so that the file is set up for early resolution, because that's what we all want, right? We don't want it dragging out to litigation. I mean, right now, my files, litigated files, are taking 6 months to a year. And some of the cases that we're going to look at are appellate decisions, and by the time you get to the appellate court, you're probably 4 or 5 years removed from the date of loss. And, we don't want that. Our customers want that quick turnaround, and I think you'll be in a better position to get that claim resolved early if you document your damages with experts early on, okay? Failure to meet the burden of segregating covered and non-covered damages can be fatal to your claim, and again, we'll go over some examples where people failed to do that, and a claim that was worth $6 million was thrown out by the court, not covered, because you failed to segregate, or at least give the jury some ability to segregate between the pre-existing damage that was on that commercial roof or that hotel versus the damage that was covered, okay? Now, I wanted to throw this case in here, this Bible Baptist Church case, and thanks to our friends at Daly and Black, they were able to get a judge in the Northern District to admit that wear and tear might not actually be a peril. And I know this is being recorded, so I don't want anybody to say, hey, I went to Path to Indemnity and Cliff said, wear and tear is part of the concurrent causation analysis. I agree with this judge, but again, you don't want to wait until we're relying on judicial opinions. I would say, even if it is wear and tear, go ahead and address that pre-existing damage, that wear and tear, because, wear and tear and deterioration is on every property. No one has a brand new house, no one has a brand new commercial building, all right? We're always gonna see it. It's incumbent on us to document it and address it so that we can say, yeah, I know, the roof had deterioration on it, but it was working fine until this storm, and I have the experts to prove it. Essentially, the way to defeat, application of the concurrent causation damage doctrine is to show that, one of two things. Either 100% of the loss is covered by a covered peril, and, an easy example of that is a fire. Yeah, I understand the apartment complex had some maintenance issues and you had some complaints from tenants, but it was fine, it was livable until the fire came along to destroy it. That's a simple one. But where it gets more complicated is where you've got pre-existing damage mixed with, a hail or a windstorm or overlapping storms. My office is in the Dallas-Fort Worth area, and it's been a crazy storm season. There's a hailstorm every weekend, so especially on commercial buildings. You're going to have overlapping storms, and it's incumbent on us to sort of fix a certain date of loss in order to, again, set the file up for early resolution and to avoid, if it goes into litigation, avoid the application of this concurrent causation doctrine and the case being thrown out by a judge, okay? All right, pre-existing damage. Does anybody see any pre-existing damage up there, right? If for those of you guys that handle, commercial claims, I haven't been on a roof where the HVAC units didn't look like that. They're always beat up, overlapping storms, you can tell. And I remember this, I pulled this picture from a case I worked on, and I remember one of the things I like to do now is maybe a week or so before the engineering inspection, I'll get up there, bring my team up there, and we'll go and, clean all the debris and junk off the roof, because again, you get up there and there's, beer bottles and debris and trash. And I remember even one time, I found a soda can and it had, Troy Aikman and Emmitt Smith's picture on it. It was from like the Cowboys Super Bowl back in 1995, It's like somebody hadn't been on this roof in decades, But you know what I did? I still remember that. I picked up that can, I put it in my pocket. I was like, this might be an heirloom someday, if we ever get back to the Super Bowl, right? Any Cowboys fans here? Yeah, let's go. Yeah, I think we're looking pretty good this year, All right, so again, one of the things I want to drive home today is that retain great experts. On that case with the, HVAC unit, We brought, some HVAC techs, some guys I work with on prior claims to prove that, hey, yeah, I mean, this unit, did it have problems before? Of course. It was limping along, it was fine, until this storm. And let me show you why this storm, caused it to become not operable and now, a covered loss, Document pre-existing damage. Don't just ignore it, okay? Again, especially on commercial claims, there's gonna be pre-existing damage. I mean, there are gonna be maintenance issues. We just have to address them, document them, and get with the, proper experts in order to help us do that. And then just set the file up for an early resolution. Just a few examples of things that I do in order to document the file. When I see, overlapping storms, issues, et cetera, is ask for the underwriting file. I mean, now typically, they're not gonna wanna give it up, but to me, once the adjuster starts raising these issues of like pre-existing damage, et cetera, all right, well, show me the underwriting photos. I mean, did you do an underwriting inspection? Quite often, I mean, back in the day, insurance companies actually did real underwriting. Now they just write anything and, cross their fingers and hope for the best kind of thing. But if they did actually do an underwriting inspection, typically you'll see things in there, admissions that the property was in good condition, it was insurable and met their, underwriting guidelines, et cetera. Then 2 years later, you have a claim and they're acting like it's the building's gonna fall down, Well, why'd you insure it, So I always find some really good nuggets in the underwriting file. And then there's typically, again, pictures of the conditions of the roof, pictures of HVAC units. And sometimes, the pictures will show the pre-existing damage, but we can take those photos and compare them to the current photos from the recent storm and say, hey, look, I mean, I can see the differences. Like, look at those dings versus like the large dings we have now, which are consistent with the size of the hailstorm that we're dealing with in this situation. So yeah, they're not gonna give it up easily, but ask for those underwriting files and push for it until they give it up. Okay? Prior claim files, that's another tool I like to use. Typically, sometimes we can't always, trust the clients, to remember everything that's happened with their property. There's several times where I'll ask, my client, have you ever filed any prior claims? Nope, I've never. And then I'll ask for prior claim files, and there's a plumbing leak that they filed, a couple years ago, okay? And sometimes, again, I'll find, nuggets in those prior claim files. So even if it's a roof claim and there's a prior like plumbing leak claim, well, that adjuster that adjusted that loss typically takes photos of other areas of the property. They might have a picture of the roof, or they might have a picture of the fence, and it looked fine 2 years ago. Now it's beat up. So those are always good places to look. And even with prior claims, prior denial letters or partial coverage letters. One of the things that I see a lot from carriers now is if there's a prior claim, they'll say, yeah, we agree there was a hailstorm or a windstorm, but the damage is under your deductible, so we don't owe you anything. Okay, great. I mean, you looked at the property before, you said the damage is under the deductible. I'll go to my clients, did you do the repairs they told you to do? Yeah, we got somebody out here, we, sprayed the fence or we did this. Okay, we did everything you wanted us to do, now what? Now we have a new storm, we have new damage, and use that information against them. So again, that's just one of the things I like to do, and these are things you guys can do before it ever gets to someone like me, On commercial properties, maintenance records. Now, on residential, I mean, sometimes, most homeowners don't really keep up with, every invoice or, et cetera, that they did to their house. But, with my commercial property clients, they typically, for tax purposes, keep detailed maintenance records so we can show, hey, we had a roofer up there, last month. We didn't see any damage, we had somebody up there servicing the AC unit, it looked fine. Our routine maintenance guy that takes care of the buildings, I mean, he was just in this room, changing a light bulb. He didn't notice any leaks. Now we have leaks, So these are, again, some of the tools we can use to address the pre-existing damage, maintenance issues that every property has, but aren't addressed early on enough in the claims process before it gets to someone like me, and then now I have to deal with these concurrent causation issues, overlapping damage issues, and by that time it can get kind of difficult. Again, I'll say it again. I know I've mentioned it a few times, but experts, yeah. I always rely on experts. I find an expert in that field of expertise, that's a point of contention, and I rely on them to, allocate the damages for me, provide affidavits, reports, engineers, et cetera. So again, document the pre-existing damage. Don't ignore it. It's present on every property, and it's just better that you address it early on, and it builds credibility. I don't know about you guys, but I'm starting to see a lot of the same players on the carrier side on a lot of my files. I mean, Nelson Forensics, I'm up in North Texas. They like to use this company called Boyd. I mean, I see these guys over and over again, and if I'm honest with them and I say, yeah, I agree with you, that's a pre-existing damage or that's a deterioration, that builds my credibility for future claims, because they'll say, hey, Cliff's he's a straight shooter. I'm not trying to claim everything's hail damage when I know it's not, okay? And then also, in your analysis, take the time to explain why, despite the pre-existing damage, the roof still needs replacement because of X. I mean, it was fine before. We understand that there's, pre-existing damage. But after this storm, it started leaking. After this storm, tenants started complaining. So obviously something's different. Something happened here. And then you can get your experts to kind of drill down into, what exactly the problem is. Okay. And lastly, I'll say, and this kind of goes without saying, just be honest. I mean, again, I don't claim something's hail damage if it's not, or attributed to the storm when it's not. And because sometimes, a repair is enough, and, again, I don't know about your experience, but I've seen some really expensive repairs, Sometimes when they walk into that, oh yeah, let's do a repair. Okay, well, yeah, here's our repair bid. Here you go. It looks just like almost close to the replacement bid, I mean, to do the job properly, So sometimes, you don't always have to fight for that full replacement or repair. Sometimes, it's sufficient. It stops the leaks, especially on some of these commercial claims. I mean, you got tenants complaining, et cetera. So sometimes, that's the proper way to go. So I'll go over some examples of cases involving concurrent causation issues. This first one's a tornado claim, and this one the court said that the evidence that the roof did not leak after the 2016 hailstorm, but did leak after the 2017 tornado to the point it required a replacement was enough to satisfy the concurrent causation issue to segregate damages. Now, again, I will caution you guys, this is the bare minimum. I mean, I wouldn't just rely on, one statement from one expert. I mean, document the file, work it up, address these issues early on before it gets to the point where a judge has to decide it, decide who's right. There's another case where testimony from the public adjuster who stated the roofing system completely failed and the damage was absolutely caused by the hurricane. That was enough, right? Then I kind of pulled this one from the Lyons case, and that was that 1993 Texas Supreme Court case that kind of started all of this. But in that case, Lyons, the insured, and her neighbors, they testified that there was no pre-existing damage to the staircase or brick veneer, and that constituted enough evidence that the extent of damage was attributed solely to the windstorm, right? So, testimony from the insured and their neighbors was enough, but again, I would rely on experts. I mean, you don't want to, rely on, kind of lay testimony because, sometimes, under cross-examination, people say strange things. So I would go with experts. Then I wanted to point out one last case where it went the other way. All right. In this case, there was a Hurricane Harvey case, and the court pointed out that pronounced granule loss at the safest access point due to foot traffic, Google Earth photos that showed at least one shingle was missing before the date of loss. Uh-oh, Google Earth. It came back to bite them, right? It showed that there was some missing shingles before Hurricane Harvey, and then that it was a 25-year roof that was at least 16 years old. And in this case, the judge actually threw the case out because the policyholder failed to segregate or account for all those issues that the judge pointed out. They just had a global, we need a new roof type estimate, instead of saying, yep, we acknowledge these issues, but this is why Hurricane Harvey, sent this roof over the edge. So again, be careful. I think I'm doing pretty good on time. One thing I wanted to point out now, we're starting to see what are called anti-concurrent causation clauses creeping into insurance policies, right? So what the carriers are doing is, I would say for a while, they're losing a lot of these concurrent causation issue cases. Judges were kind of going with, PA testimony, a testimony from neighbors. So what do you do when you're losing? You rewrite the rules, right? They've got all the power, so they just go rewrite the policies, and they put in their clause that basically says that the typical anti-concurrent causation clause excludes coverage for any loss or damage caused directly or indirectly by an excluded cause, regardless of any other cause or event that contributes concurrently or in sequence to the loss. So again, just in layman's terms, if you've got covered and uncovered, losses, the anti-concurrent causation clause means that the claimant's excluded. You don't get an opportunity to segregate anymore. They've taken that away. And I know for a fact State Farm has, a lot of State Farm policies have that clause in it because it's been used against me in some of my cases, So the stuff is coming, so now you don't even get an opportunity to segregate. You have to prove that 100% of the loss was covered by a covered peril. 100% of the loss was from the hailstorm. 100% of the loss was from the windstorm. 100% of the loss was from the hurricane. They've taken that ability away for us to at least prove that, yeah, I understand there's pre-existing damage or deterioration, but the storm came along and caused all of these leaks. Okay? And then lastly, I'd point out this is a recent. This case came out right around COVID, so it kind of flew below the radar. But it was a judge in the Northern District says that the Fifth Circuit, which Texas is in, and the Texas Supreme Court agree that reading exclusions and anti-concurrent causation clauses together excludes from coverage losses caused by both a covered risk and excluded risk. Again, that's just a fancy way of saying now we don't even get a chance to segregate anymore. We have to prove that 100% of the loss came from the windstorm or the hailstorm. So be aware of this. It's coming out, and once one carrier gets away with it, they all start copying each other. It's unfortunate, but that's where things are heading. Yeah, with that, I'll throw it out to some questions. If you guys want to, dive into anything I've discussed today, and I'm open to questions on, I guess, anything else you guys have. Anything? All right. Oh, Sean. Yeah, exactly. Great point. Yeah, and yeah, that was, and I remember when, I would be involved with claims just like that, where we only had 1 or 2 broken tiles, and that happened in Harvey a lot. I remember I had a lot of Harvey claims where it was just 1 or 2 broken tiles. Somebody had a discontinued, tile letter, from like Boral or somebody like that, and they were saying that was sufficient to, to buy the whole roof, and that's going away now. The carriers are saying, well, we only owe for those 2 tiles. That's what, was damaged from the storm. Because something's discontinued, that's not a covered peril, and that's where that, that kind of, wear and tear peril language kind of comes into. So be aware of that. I mean, yeah, those, the days of, the 1 or 2 broken tiles getting you there is kind of going away. So yeah, thanks for bringing that up. That's a great point. All right, any other questions? All right, yeah, well, I guess I thank you guys for your time. Again, oh, there we go. Yeah, great question. Now, I certainly provide some guidance. Written, I would steer away from that, but because I don't want to create that paper trail between myself and that expert. I certainly want it to be the expert's independent opinion, but sometimes, they do need a little coaching just to kind of narrow the issues, so I can point out, like, this is the problem. I mean, this is what the insurance company's saying. This is the problem we need to address. Let's narrow, let's focus on that. And how do we do that? Now if we can't do it, tell me, but if we can, how do we get there? So yeah, certainly. Yeah, great question. Any other questions? Okay, all right. Well, yeah, I guess I was pretty much on time. So yeah, I want to thank you guys for listening to me, and I had my contact information there if anybody wants to call, discuss anything, I discussed today. I'd be happy to. Feel free to email me, call me. I really do want to be a resource, and want to thank Sean again for inviting me to speak here today, and hope you guys have a great conference.
Thank you, Cliff.